Human rights lawyers and refugee supporters have condemned the Albanese government for attempting to avoid the High Court's decision yesterday that onerous limitations on those released from custody constitute unjustified kinds of punishment. Instead, the government has chosen to enact broad new legislation that would reinstate invasive curfews and ankle bracelets, grant the government the authority to deport people to unknown third nations, and risk sending people to locations where they could face real violence. The Asylum Seeker Resource Centre, Human Rights Law Centre, Refugee Advice and Casework Service, and Refugee Council of Australia are deeply concerned that the new legislation puts refugees at risk of being returned to unimaginable harm, will result in indefinite family separation, and blatantly undermines the fundamental principles of equality under the law. Welcome to the channel. Please, if you're new here, like and subscribe so you don't miss new updates and hot gists. If passed by Parliament, the government's new legislation will. Experts have condemned the Albanese government's clear attempt to absolve Australia of its international responsibilities and domestic civil liability, accusing the legislation of undermining the High Court ruling and further punishing refugees, asylum seekers, and migrants. The new proposal reintroduces components of the controversial Migration Amendment, Removal and Other Measures, Bill 2024, which stalled in the Senate in May, according to Jana Favero, Deputy CEO of Asylum Seeker Resource Centre. Yesterday's High Court ruling presents a chance for the Albanese government to uphold the rule of law and allow asylum seekers to rebuild their lives in the society alongside others. Unfortunately, it is not unexpected that Labour has prioritized politics over people by demonizing and punishing refugees, asylum seekers, and migrants. We are a proud multicultural community, and everyone deserves to be treated equally, regardless of where they were born. The scope of this legislation is both startling and obscene. The dangers of offshore imprisonment and transporting people to third nations are widely understood. Despite this, the government is actively seeking to expand our use of detention, both onshore and offshore. According to Samiti Varma, legal director of the Human Rights Law Centre, the High Court's decision yesterday signals an end to the ongoing demonization and punishment of a small group of individuals. By this stage, they have been punished 3 times, with a criminal penalty, an indefinite period of confinement, and draconian monitoring and curfew circumstances. Now, the administration intends to store people in undisclosed foreign countries. Many of those released from jail have families in the community and spent their early years in Australia. They are struggling to reconstruct their lives following years of adversity. They, like all of us, need to be treated with fundamental dignity. Sarah Dale, Centre Director of Refugee Advice and Casework Service, stated that although celebrating a revival of dignity in the courts, the government continues to deny the rights of asylum seekers and refugees. Australia's offshore regime has been a failure at best, and at worst, a system of cruelty, irreparable injury, and misery beyond comprehension, only to be included in yet another brutal form, despite all we know is unacceptable. People are here for a very genuine reason: the harm they fear in their home countries, a fear so strong that they have endured an indefinite detention regime, a fear that our laws and processes have recognized as well-founded. Giving power to dismiss such a finding of fear is unconscionable. According to Graham Tom, Advocacy Coordinator at the Refugee Council of Australia, the current legislation does not offer long-term alternatives for those who have served their sentence and still require protection. Rather, it appears to provide a horrific Sophie's option of either indefinite detention in Australia or transfer to countries such as Nauru, where they may face indefinite confinement. According to Hannah Dickinson, Principal Solicitor at Asylum Seeker Resource Centre, the Albanese government has passed laws that reinforce visa conditions that were previously deemed unreasonable and unconstitutional by the High Court. These laws go much farther. Not only do these laws allow for the troubling warehousing of people overseas, putting them at danger of the worst forms of abuse, but they also openly aim to relieve the government and unidentified third countries of responsibility for the wrongs done to people in the process. The refugees subjected to this brutal regime have families and communities, and many have lived in Australia for the most of their life. They enjoy the same rights as everyone else: liberty, bodily integrity, family unity, and privacy, as well as the ability to restore their lives. However, unlike those fortunate enough to be Australian citizens, they face recurrent and catastrophic punishment. We urge the Albanese government to put an end to this terrible and unacceptable cycle.